Cool. I assume that I'm still audible.
You are.
All right. Okay, Barry. Speech starting in 3, 2, 1. What does the international cricket court look like in the status quo? Like, this debate's going to be so boring. I couldn't resist the patter. I'm going to do 3 things: one, a model; two, ICC bad; three, regional courts good; lots of mechs; maybe a principle if I have time. 3 points under a model. One, I think we're going to do this in quite a gradual, staggered basis in order to wind down current operations within the ICC and adequately build up regional courts and infrastructure within other states. How are we going to do this? Second point in the model. I think we are happy to stand over one, current transfers of capital to regional courts in order to make sure that they are going to be adequately established. Two, I think we're happy to stand over a transfer of experts temporarily in order to make sure that there are enough legal people within these institutions to do all that legal stuff. I did law for a week. I don't remember anything else. And then thirdly, I think we are also happy to spend some capital currently present within the ICC to create educational institutions or other infrastructure that allows people to gain adequate legal skills in order to build up the infrastructure present within these. Third of all, we think in order to incentivize membership for these, we are likely going to make regional trade unions or bodies like ASEAN or the EU have a contingency regarding your regional court existing in order for you to participate within these unions. This is likely going to get a high degree of buy-in for them. Cool. I think there are broadly two metrics that courts require in order to function. I think first of all is some degree of functionality within them intuitively, and second of all, a degree of buy-in to respect the decisions that are made by them, even if functionality is achieved. I'm going to explain why the ICC lose out on both of these required metrics and explain why regional courts are comparatively better. I want to broadly note 5 reasons as to why the ICC is entirely non-functional. One, I just think there's a huge lack of border cooperation when you are trying to engage in transfers of people that have committed crimes against humanity. Specifically, what does it look like? I think it looks like the fact that if somebody has committed a crime against humanity, you don't fucking want them traveling over your borders at the point at which you are trying to transport them to get prosecuted, meaning that the actual ability for you to transfer them from one regional location where they have committed crimes, the ability to then extradite them is extremely slim, particularly given that they can just keep hopping around borders and nobody who is within that state is going to ever take the risk of actually extraditing them. Secondarily, because you are actually exchanging your internal information with a large regulatory body that has some of your enemies within it, I think it is perceived to be a security threat to engage with the ICC because of the confidential information you are giving up. Because you don't have to take that trade-off when all of it is taken internally, it is comparatively more likely. Thirdly, I just think hardly any people fucking join the ICC, and often these are the people who are committing the worst of the worst things, meaning that at the point at which you don't have any incentive for them to actually participate within the infrastructure, loads of crimes are getting unpublished. Fourthly, I just think the ICC is fucking racist, right? Like, there's a reason why 80% of the crimes that they have tried from the leaders that they have tried to pull people are from Africa. And the reason for this is that the experts who currently populate the ICC have grown up in states where they had a post-colonial lens through their education, whereby they perceive continents like Africa to be filled with people who are not capable of running their own states, have a barbaric other, shout out Saeed, who they necessarily perceive to be someone who is going to commit these crimes, and subsequently they clamp down on them way harder than they would for any group. Sure, clarification.
Right. So can't not the ICC take cases where prosecutor basically like press charge, right? It's like we can basically just assume that the Africans people are more likely to get charged. What actually changed?
What? No, it's regional courts, so it changes because it's going to be populated with people from their own states and their own cultures, rather than people who've grown up in a racist education. Cool. So at the point at which we have grown up in this racist education that otherizes these people, I think this is specifically the point at which we are going to treat these people worse because they perceive them as a greater threat. Fifthly, I just think it is perceived to be a Western imposition in the majority of states, meaning that cooperation is going to be really bad because they don't engage with it for things like testimony, because they perceive it to be an infringement upon their rights and their identity. Secondly, in terms of the perception, lagging on from this, because recognize at the point at which the ICC is seen as an extension of a colonial legacy, which states have often specifically formed an identity in response to, it is not only bad in terms of its function, but even in the best case, when it does acquire some degree of functionality, it is never going to be perceived as justice because it is perceived to be an an imposition on them and a direct attack on their identity. What are the impacts of this? I think broadly threefold. I think first of all, you're significantly less likely to get justice because people don't buy into the system. I think secondarily, even if you do get justice, there is the perceptional harm that people don't perceive themselves to have had justice, and subsequently this is harmful. Sorry, COO's clarification was really long. And then thirdly, I think at the point at which it reduces the deterrent for you to not commit war crimes in the future because you perceive it to not be functional, I think more war crimes are going to happen. Less people get justice. That probably fucking sucks. Why are regional courts comparatively good? In terms of functionality, 5 things in this. 1, it has a link to the bodies that you want to cooperate with, meaning that there is a direct incentive for you to have some degree of participation. Secondarily, it is not seen as a colonial infringement, meaning you are now able to reconcile justice with your identity. Thirdly, you lose the security threat of exchanging confidential information with international actors. Fourthly, often there is the times when laws disalign. It is to say that there may be a different method in which you want to prosecute something than the ICC do. And subsequently, I think the ability to have that flexibility means that you are able to get better justice and better cooperation. Fifthly, I think the timing is important. Intuition pump. Imagine if the ICC tried to go in and do some shit in Myanmar right now. It wouldn't fucking go down well, but because they don't know the internal makeup of states, often they are going to attempt to engage in prosecution at the wrong time. It is better to have an actor that is proximate making this assessment, and subsequently you are more likely to get justice that is better, that is what these people want and is timed correctly. Why are we more likely to get buy-in? Recognize that it is not going to be perceived as an enactment of justice when it is perceived to be an imposition, which is to say that at the point at which the justice that we get is something that is bought into, people are more likely to perceive themselves as being free from this because it is something that they can form a collective identity around and engage in a Stiltbingen process when they feel like it has been some sort of consensus decision, when they are more likely to respect the result as a consequence of it. I think this is specifically the point where justice happens, justice is listened to, people perceive there to be justice, and people are able to move on as a consequence. Finally, the principle. I think of the point at which more people are able to access this court, more people are able to relate to the coercive state mechanisms of justice when they are able to participate in the institutions that legitimize and enact that monopoly of violence. Easier access is good, more justice, justice slaps.
I'd like to thank the speaker for that speech and invite the Leader of Opposition to start the case for opening opposition. Hear, hear.
Right, I hope you guys can hear me well.
You're audible.
Great. I'm just gonna go get my timer. POI, please in the chat. I will try to take one around minute 5 to 5:30, preferably from closing. Any point of clarification could be taken up earlier. But please note, if you guys want to get a POI, please write it in the chat. I don't care what time. I will take you when I have the chance to. But if you guys don't write it, my brains will forget it. So yeah. Just give me evidence. That being said, I will start my speech in 3, 2, 1. Panel, even if all of the things that the OG has mentioned until far about the non-functionality of the ICC, we believe that we're better off on outside the house. We just stick on the ICC and are okay with reforming the ICC. For example, giving them more funding to get better commissions, or introduce quotas on how many, what kind of prosecutions they should be taking up, right? So maybe a little bit less on Africa, a little bit more on Southeast Asia, Myanmar, Laos, stuff like that. But what we're not okay with is basically the fact that the OG thinks all of the problems they presented to us, it's going to be resolved the moment that we turn it into a regional court. What I'm going to do in my speech is very simple. First of all, I'm going to tell you exactly what the regional, what the East ICC is actually good for. And why, the regional courts, at worst, at best case scenario, they probably are just going to be as bad as the ICC, and worst case scenario, they even are going to be worse. And then I will also introduce you one of the more nuanced mechanism about how is it on outside the house that we get better prosecutors protections, especially if we consider that many crimes charges against, many prosecutions charges against crimes against humanity is like being charged against still living people, even like still living dictatorship, and people probably don't feel safe if they have to live and also press charge in the proximity of that region, right? So like let's just first go into the clashes. We basically see two biggest clashes on like the ICC versus regional court in this debate, right? First of all, on neutrality, and second of all, on functionality. They noted that like the regional courts is not exactly 100% that better than the ICC, because if OG tries to claim to you, oh well, the ICC is only comprised of like white freaking elites who think Africa is bad and therefore only prosecute African people. But the thing about like if you actually bring it to regional court, it's also just going to be as bad, because like you are also not going to get that's much more of like the diversity diaspora. What you're going to do is basically you put them into a region where there's going to be biases, there's going to be also elites who probably are going to be more likely to make into the court. What does it look like? It looks like some countries who are richer, who are better off, can set more, do have more educated people, do have more lawyers that end up being judges on that particular regional court, but it doesn't mean that like we can get people who present ideologies from everybody else, right? And also like if you actually have presenters just within the proximities of the place where people are also being charged against, like we also believe that's going to raise a lot on like the lobby efforts from the defendants themselves. Noted like many cases where in crimes where people commit crime, they also are dictators and they probably are like have very good financial backings where they can actually be just corrupting the regional court overall. So we believe that actually that's going to get the neutrality of the court itself down, and therefore doesn't necessarily lead to like a better judgment in how to judge the crimes. Second of all, on the case of functionality, so OG tried like introduces ideas of, oh well, the ICC is non-functional because like extraditions and like transport and transferring is very, very hard. We don't know how is it actually that they want to change it once it's become a regional court, because a regional court is still going to be placed somewhere within its region, right? It's not like every country is going to get one court of their own. That's actually going to be very, very bad on the logistics. But what they can then do is that basically all those people who got like charges again can just go out of the region before like the case got finalized, and therefore it also just escape extraditions. On the other, like on comparison to that, the ICC is allowed to basically like create warrants all over the world, and therefore even if you try to create like if you try to like transfer people across borders, oh well, they are still going to be get caught somewhere, are more likely to get caught on outside of the house. And for like the security threats thing, still note like we are going to have very good funded policies and like armies who take care of this, and it's probably going to be also very, very secured. What is then exactly that the ICC is good for, right? Like we have already established the neutrality is probably the neutrality between ICC courts and the regional court is not exactly like 100% that clear. Okay, functionality, we would also even say, well, at the point where you can actually focus all of your funding into the ICC and basically try to reform it, we probably are going to get better functionality. We probably are going to get more funded so that we get better commissions, get better juries, and therefore probably still going to be very good, right? But what is actually then changed, like what actually changed then on your side of the house, basically you kind of remove the kind of protections that prosecutors can enjoy on outside of the house when the ICC is the main responsible body for it. Please note that ICC is like situated in the very functional democratic part of the world, right? And people who want to press charges, also people who need to press charges, can actually go there and like basically enjoy international recognitions and international protections. That's going to be all removed on your side of the house when it's just constrained to like a very particular regions, where then if you want to press charges, for example, against the Miami dictatorship, you cannot exactly 100% get out of your countries and don't fear being being extradited back against yours. Before I go on, closing.
What does the ICC do when it summons a dictator and they refuse to come?
Right, the ICC actually don't get to do much, right? They can't exactly just like force people out of that. But I think what ICC is good in this case is that they also make, and it's also like into our point, right? Our second point, they make they are able to garner more recognitions and also garner more international support for that particular prosecutor that's trying to come up with the case. So even if we're not allowed to prosecute the dictatorship right away, but the point where the dictatorship is weak, and we probably will expect them to be weak, right? Or like after the dictatorship is over, that at least ICC can like say, hey, everybody, look, this is a crime against humanity. Everybody should rally against it. And we believe that at the point where they can actually bring them out onto the court, then they have to own up to that name. Back to my point of like protections, we just believe that like at the point where you can believe that ICC being the only international body that's responsible for executing crimes against humanity, any court that's any court case that actually being brought up to it, no matter if it's got taken up by the ICC or not, we're going to receive more international media attention. We also receive more support, like international support, and we kind of need this for the people like who already are being very hot water, who already are being fucked up over, being emotionally tortured by those dictatorships, right? Like all of those crimes against humanity. We just say it's way better for you to have one international body who can provide protections for everybody, and also who can actually serve justice. No to regional courts, but yes to reform. Thank you very much.
I'd like to thank the speaker for a fine speech and invite the Deputy Prime Minister to conclude the case for opening government. Hear, hear.
Can you hear me?
Audible.
Cool. I think these debates can get very messy. And I think the reason for that is, as they've said, look, we can reform the ICC without an actual understanding or engagement with some of the integral flaws with the ICC that make them devoid of reform, or even if they are possible to reform, devoid of achieving the impact that their aim is, i.e. justice and the redistribution of I suppose, human rights to those affected by war crimes, right? So what I'm doing this speech is first of all talk to you about the ability to achieve justice, why it is better on our side, and secondly, I want to talk to you about efficacy. I will take a POI from CO at some point if they want to engage and be ready for that. If you can have your screen on while you do it, that'll be fab. Cool. I think that okay, ability to achieve justice. I think that opposition in this debate, like to some extent, not to be glib and be like, some of the analysis is a bit racist to say that people can't achieve their own legal systems themselves because they are not in functioning Western parts of the world. But I think ultimately, to some extent, it does stem from a kind of Western understanding of legal systems. As Jason told you, that you come from a post-colonial world in which you are taught that to some extent, either there is a savior duty put upon you based off past wrongdoings, or that ultimately you just haven't even got to that level of it yet and are still part of the understanding that these people are less educated or less capable of protecting themselves. Secondly, I think it is listening to the fact that we have linked this to existing institutions and given reasons as to why this is likely to be something that is stable and is something that has mechanisms for creating proper systems and proper processes, means that we're looking at things like ASEAN being connected, membership in ASEAN being connected to membership in this, right? Showing that states are willing to sign up to formal agreements and institutions. But finally, two more things on this. We also say that, like, as Jason said, this is about the breakdown of the ICC. So slowly, ICC transfer of resources to these other courts. So if opposition's claim is there are countries and regions in the world that are too impoverished to be able to have the resources to set up our skills, we're saying that the ICC resources are being redistributed around the world. We think that equally it could be fairly distributed, but even if it's not just evenly distributed, most of the members of the ICC are from the world's poorest nations, because note, the United States does not join the ICC because it feels it ought not to. So if we're redistributing it, it is in somewhat a reallocation of resources where they ought to be. Then if you want to say, look, knowledge is good and that like The Hague has some good knowledge, sure, international trading of laws and justices can still happen on both sides. There are people outside of the ICC who still contact foreign courts when they need advice and need engagement. We think that can still happen between these regional courts where necessary. The difference on our side is the control is in the hands of the people locally to ask for that assistance rather than it being shoved down their throats. And finally, I want to talk to you about control. I think that the basic principle of justice is that you have some level of control and access to it. We say that on our side, people around the world don't have access to it, and they are beholden to The Hague. I'll talk a little bit more about that in a moment. But finally, on this savior complex, even if they want to do some work to explain why ultimately that is legitimate and there is a duty to protect. I think that is the legitimacy is largely linked to the efficacy of the ability to save those people and impact them in terms of achieving justice. I will show you now how I think we get more justice on our side. Why? One, flexibility. I think that there is more flexibility and regional understanding on our side of the debate. Look, even in the ICC's perfect world where they are as reformed as opening opposition wants to talk to, the examples they give are an understanding as to why this needs to be regional. Take Myanmar, right? Taking into account the different laws, procedures, timelines of those countries is massively important. Knowing that you might want to intervene in Myanmar is one thing. Knowing when to intervene in Myanmar so as not to cause another major coup within that country and so as not to cause major instability with that country is something that is far easier to do when you have regional knowledge and you are closer to the situation. And equally, you could talk to people on the ground a lot easier because you are, one, more approachable, because you are not beholden to the past actions of the ICC and deemed as racist and deemed as only doing this as either a bid for control or a bid to be racist. Secondly, we think that at the point where you are trying to be involved in building new states, i.e. when the dictator has been taken away or the dictator is being on trial, the ability to be involved in the state building process is massively important. We think these regional courts can act as symbols for the creation of new systems within these countries, as positive role models and literally facilitators within the creation of these new states. But equally, we think it's just better for buy-in, right? Look, opening opposition say that ICC is in a functioning part of the world and therefore you get protections. One, access to a court is still provided on our side of the debate, but equally countries outside of the ICC to this day have extradition agreements, have safety agreements, have the ability to help people and help them achieve safety. We think that on our side that still exists. The difference is the control of requesting those agreements is in the hands locally. CO.
How can the ICC be super colonialist if, as you identify, the colonizing countries aren't even in the ICC?
They are, though, just America isn't. Like the Dutch, it's in The Hague. The Dutch were massive colonizers. Check a history book if you haven't noticed that before. Australia, I'm not sure if they're still part of it, but they do comment on it a lot, and they're quite a racist country. Sorry, Jess. I just do think that at the point where you say you aren't, that would be fun to hear. And I think that at the point where extradition is far more capable on our side, right? So now I want to talk to you about how the actual functionality and efficacy of this happens. I think we've done ability to achieve justice or what justice looks like. Let's talk about how we actually achieve it. O.P.A says, look, it won't work because there's corruption. A couple of things. One, I think we can have mechanisms against corruption, as all courts can do, right? I think like the transfer of resources from the ICC is likely to want to reduce that element of corruption, but equally corruption is symmetric on both sides of this debate. But on our side, it is far easier to point out corruption because it is not linked to a tension of race or a tension of histories, right? Your own people calling a system corrupt or being able to analyze why it's not representing them is far different from the white man calling you a corrupt African state or a corrupt African body. Secondly, on extradition, one of the problems at the moment is there is a long list of people that the ICC wants to engage with and wants to have a trial for, but they are not able to extradite them. Why are they not able to extradite them? Because there is a long perception of protecting people from this kind of outsider force who isn't doing the good for your country, but is largely just acting as a signaling effect. You say that on our side, your justice and your legal systems are intertwined with one another, because at the point where you have a regional court, it is likely that that funding goes out to incorporate justice systems together so that your police are trained in similar ways, your courts are trained in similar ways. You're likely to want to exchange resources because you know that that country you helped extradite and to help your people or their people is likely to do that back for you. The difference is yes, there are tensions regionally, but these are connected to bodies that we have said to other regional bodies. The difference is the ICC cannot do that as there are too many intersecting issues. The United States, I know they're not in it, so sorry, the Dutch are never going to trade secrets with the Russians, right? And at the point that happens, you get a stalemate and people don't engage. On our side, you get better cooperation, not perfect cooperation, but ultimately it's better. Prop.
I'd like to thank the speaker for that fine speech and invite the Deputy.
Okay, POI is in the chat. I'm going to start my speech in 3, 2, 1. I'm going to get straight into it and respond to closing government. Firstly, their claim is that the court is structurally racist because they're likely to go for the easy wins. 2 responses. Firstly, this is not necessarily the case if you assume that the win condition for the ICC is successful prosecution. This is in fact not the case. Secondly, I would just observe that the ICC jurists have said time and time again that they feel it is important to just signal prosecution so that there is awareness in murkier legal cases that they believe that this person has committed a crime against humanity. An example is the very one that closing government give, which is Charles Taylor. Secondly, they say you do not want war spilled over to your borders, therefore you have an incentive to do this well. I think the problem with this is there is a time lag problem. Often war has already occurred at that point, and then you realize you need to prosecute. So it is unclear sort of how that mechanism works there. Their final claim is that the ICC is already dying. Like, I kind of don't think it is. They're like still initiating prosecutions on like a very regular basis and having regular discussions. Also, if your main kind of reason for this is politicization, international institutions survive politicization all the time, like see the UN, that's not dying. So I'm just not particularly sure of the impact of CG's contribution to this debate. I want to add one separate rebuttal to opening government before getting into our case, which is just about flexibility. The question kind of I wanted to ask them is, what specific part of the Rome Statute would you have amended opening government? Because if you can't identify what specific provisions you need changing and to be flexible at the moment, I'm just not sure this holds a lot of weight. The reason why these laws have been crafted and they've been done so by a raft of different jurists from different countries over time is because it took a while to kind of get to agreement on what we think, these sort of laws should look like. So like if flexibility means like more kind of caveats for people that might have committed war crimes, this may not be a good thing. More on that later. Okay. I want to give some characterization right off the bat. I think the problem with the rest of this debate thus far is they've kind of just chucked out words like dictators without really telling you the different types of circumstances these cases often occur in. Most often they occur in two types of scenarios. The first is where there are dictators that are currently still in power. So in those sort of circumstances, they probably have the same level of incentive not to cooperate with the ICC as they do in a regional court, because under both, like they probably don't want to go to jail. So I'm not sure why they'd be more willing to cooperate with a regional court. They still don't want to go to jail on both sides. Or you have post-conflict societies, i.e. societies where you have a new government that might have, for example, overthrown the previous regime, or you've got some sort of power sharing agreement, right? Because of the way that those governments often manifest, they probably have some opposition to the previous regime, which might have committed war crimes. Therefore, they probably have incentive to cooperate with both bodies on that side, right? So this immediately removes opening government stuff about extradition. This characterization will also become more important as I get into more prongs of my extension. I want to now go into a lot more detail about why comparatively these regional bodies are likely to be bad. Because like, again, I think all teams in this debate agree. The ICC is far from perfect, but this debate is a comparative one about what is likely to be worse. I want to note here that opening opposition just say some kind of glib things about prosecutorial protection and dictatorial corruption. I think we're going to add far more depth here. Okay, the first observation I want to make is one of capacity. Opening government has the most farcical mech here, which is just like, but we're going to redistribute this money. Like, sure, initially, but these things require ongoing funding. You cannot fiat these countries being willing to fund these things year after year after year. And who do you think bodies are going to be the least funded? Countries that come from economically poorer states. So yes, the ICC could do with more money. The problem is the comparative. Who do you think is likely to be less funded? Probably courts that come from countries without economic power. The second reason is that the second reason why these courts are likely to be bad is because you're likely to just have historical relationships with those countries, right? So if you are like talking about a dictator that is still in power, like chances are they've probably traded or engaged with diplomacy with other countries in that region on comparatively more so than they would have countries in other regions, right? Like, don't even think about Africa in this instance. Think about the USA. Like, imagine the USA on a fucking regional court. Like, yes, it's not great that they haven't signed up to the Rome Statute at the moment, but can you imagine them trying to weasel their way out of a regional court? I'm going to expand on that more later, but that would be pretty fucking bad. And thirdly, like, if you happen to be, and I appreciate this doesn't occur in all circumstances, if you happen to be dealing with similar conflict issues in your state, see, for example, the Congo and the Central African Republic, public, you probably do not want to indict leaders at the point that it might set a precedent for you. And this is the crucial framing in this round. So please pay attention. We would prefer, with all of this in mind, that regional courts or the ICC or whatever are more overzealous than underzealous, right? I concede it is not great that the only, leaders that have been prosecuted are those from Africa, right? But would you rather those leaders not have been prosecuted? Like, I think the comparative here needs to be engaged with. Like, yes, that's not great. We would have wished they prosecuted more, but it's probably good that they prosecuted those people. Like, worst case, maybe a dude who wasn't guilty of crimes against humanity, but just fucking slaughtered a lot of people gets over prosecuted. Like, the comparative is no prosecution because of the reasons we give you. So, that's probably bad. Okay. I want to, before I continue, actually, I'll take a POI from opening government.
Okay, we increase funding, engagement and cooperation as we increase the mandate to join by linking membership to existing bodies in that area. If you wanted to challenge that mechanism, you have to do it in POI's top half. No one did.
No, I can still rebut you now. I've already said that, like, they just don't have the funding because they don't have economic prosperity. Okay, let's look at now the framing of maybe both bodies are not perfect, right? And I think this is really a crucial contribution in this round, right? Because let's note what the context of the ICC it is. It only applies with complementary jurisdiction, which is when a local court or tribunal can't or won't prosecute, right? So actually, I think there's kind of funky, cool benefit where even if states fucking hate the ICC and would prefer a regional court to the ICC, that kind of works for us because you're more likely to speed along a domestic prosecution. And I think this is probably played a significant part in tribunals that we have seen historically. For example, Cambodia, for example, Japan, Srebrenica, Sierra Leone, and so on. And this is probably better, one, because compared to both possible bodies, they're likely to be more efficient, but they're also likely to be more accepted sort of in post-conflict kind of rhetoric kind of way. And this is not a contradiction to the earlier analysis. They apply in different scenarios, i.e. one is more likely to occur in dictatorial regimes, the other is post-conflict societies. I would also just posit it's pretty fucking bad if the US can just weasel its way out of a regional prosecution. Probably better, everyone knows that the US is just a dick and doesn't want to sign up to the ICC. Probably means you can weaponize that narrative against them. For all these reasons, very proud to oppose.
I'd like to thank the Speaker for his fine speech and invite the Government Whip to conclude the case for closing government and the government bench as a whole. Hear, hear.